Hey everybody, Paul Rabley here. Okay, another big YouTube live stream. Just let's have some fun here to start. Busy day for me. Had some great Zoom meetings with 4 or 5 couples. Had a staff meeting with my staff, so got a lot done. It's been back to back to back. In addition, dealing with some cold weather. So I don't know where you are. Obviously, I don't know where you are, but got some cold weather going on. So schools are closing and that kind of thing. So if you're in a cold weather area, stay warm. All right, we got a lot to jump into. Let's do it. So today's live stream, if you have a living trust, do you need a will too? I get that question so often. The way the question develops is we start talking to people out of our law firm. Link in the description below if you want to set something up. But we start having these conversations. What do you want to accomplish? A lot of people, even in the initial, when we ask, what do you want to accomplish? A lot of people say, well, we want to do this. I want to protect my spouse. I want to do this for my kids. And then one of their line items sometimes tends to be, I want my survivors to avoid probate. And they usually comment something like, boy, sounds like that would be really hard. Or maybe they went through it when a parent passed away, or maybe they went through it when a parent had a trust, and maybe it was easy. Maybe it was difficult, who knows? But many people do have the goal of avoiding probate when they pass away. So the knock on probate takes a long time. It's a government proceeding. Courts are involved. Lawyers are involved. Judges are involved. That's that probate that's proceeding that's necessary. It's that proceeding that's necessary if you pass away with assets in your name. Got to go through lawyers and courts and wills and in order to enable these survivors to access the assets that from the name of the person who died into the names of the heirs. So this really isn't an avoid probate discussion, but when we have that, maybe we should set up a living trust to avoid probate. Let's discuss the pros and cons. The question usually arises, well, if I have a living trust, do I need a will? Okay. So real quick, gotta say props hello to Larry for coming out again from Bakersfield, California. We got Victoria from Texas, and we got Rosemary from Hawaii. So good catching that southwest part of the United States, including Hawaii. Great to have you. Some of the housekeeping rules, if you are a subscriber, and I don't know what you're looking at, but it should be fairly easy to subscribe to my channel. Subscribers can go ahead and type some information into the chat. What I'm looking for is some comments, some experiences, some questions. Be as clear as you can. After I present some information, I'll go to the chat. We'll go through them one by one. I'll address the ones that are appropriate, and we'll have a great evening. So 3 things I want to cover in this. If you have a living trust, do you need a will live stream is 3 parts. Number 1, what's the difference between a will and a living trust? Number 2, let's get right to it. If you have a living trust, do you need a will? And then number 3, things to watch out for when you do have a will and a trust. Okay, I'll sneak over and say hey to Brendan, Missouri, and hey to Vicky from Florida. So we're starting seeing the geography expand, which is fantastic. All right, number 1, difference between a will and a living trust. I always like to say kind of the will is the traditional way that people have left things to their heirs. It's also referred to as the old-fashioned way. In the old movies, or even in the new movies, when part of the movie, part of the story is about somebody died and left assets to someone, it's typically somebody died and here's what their will said, or somebody died and they went to the lawyer's office to have the reading of the will, which, by the way, almost never happens these days because information gets shared electronically. And so, in the movies, in the stories, it's all about somebody died and what did their will say? Because the will is the way it, traditionally has been done. So most of you have, at least in concept, you understand what a will is. And maybe in the movies and in the novels, you've read enough about it. Somebody has a will. They say, I, John Doe, declare this to be my last will and testament. I revoke any prior wills made by me. Section number 1, I'm married and I have 2 children. My spouse's name is this. My children's name is this. Next section, I leave $25,000 to the church. I leave $10,000 to the hospital. I leave $10,000 to my good friend. And I leave the rest of my estate to my 3 children to be divided equally. I name my oldest son, James, as the executor of my estate. So that's generally what a will is. And the concept behind a will is fairly simple. You leave all of your assets in your name. Your house is in your name. Your accounts are in your name. That seems to make sense. You want assets to be in your name. And then when you pass away with your will, then your assets, other than your retirement accounts and life insurance policies who have beneficiary designations, those beneficiaries can get your death certificate after you pass away, go to the financial institution and deal with those non-probate assets where the financial institution who holds your IRA, for example, will transfer your IRA to your beneficiaries outside of any kind of probate. And really, regardless of what your will says, if you have a will that says, when I die, I 100% want to make sure that my IRA goes to Fred, but on your beneficiary designation at the financial institution, your paperwork says that you've named Betty as your 100% beneficiary of your IRA, your IRA is going to go to Betty when you pass away, regardless of that bequest in your will. But so you're likely to have some non-probate assets. You may have some assets in your name, and that's the assets that the will govern. So person dies, they have a home, they may have a business, an LLC, a corporation, investments, stock, bonds. They may have various types of assets in their name, boats, trailers, airplanes, you name it. And but they have things titled in their name. So then what happens is typically those assets are frozen. Nobody can get those assets in their name. No one can go to the bank and say, hey, my dad died. He left a will. Here it is. Give me the money. Money was left to me. Doesn't work that way. So when somebody dies with assets in their name, they have a will, then the will does control who inherits the assets, and the will controls the disposition of the assets that are in your name when you die. And the way it typically works is your survivors will hire a lawyer, and lawyers will guide the heirs through a court and attorney involved process, because there's a well-defined process that takes place when somebody dies with assets in their name and a will which directs where those assets go when they die. There's also a process where if somebody dies with assets in their name and they don't have a will, then the state laws that govern who gets someone's assets when they die controls who gets that. And all those parties will go through a probate proceeding, and ultimately a judge will sign court orders transferring assets to the appropriate heirs. Every state can be different on who inherits from you if you die with assets in your name and you don't have a will. So typically it's your closest relatives in some form. If you're not married but you have children, likely to go to your children. If you are married, then there's, your spouse is going to come into that somehow. If you're not married and you don't have children, it's likely your nearest relatives, maybe siblings, for example, or children of deceased siblings. So anyway, that's the will story. I, John Doe, declare this my last will and testament. I leave my estate to my 3 children, and I name my oldest son, James, as the executor. I pass away. Assets are in my name. All those survivors grab the will. A judge declares that the will is valid. Inventories of assets are prepared and filed at the courthouse, and judges sign various court orders ordering, based on the terms of the will, that assets be dispersed to the appropriate heirs. Okay, so that's your will. That's typical. That's traditional. Next, we'll talk about what a trust is. And there's a lot of different kinds of trusts. Even if somebody has a will, there could be a trust within the terms of their will. Someone's will could say, I, John Doe, leave $1 million in trust for Freddie. And so-and-so is the trustee of that trust. Freddie can have a third of it when he's 40, a half of what's left when he's 50, and the rest that he's 60, because you don't want Freddie to blow it. You don't want him to get it in one big chunk in one big lump sum. So when a trust is defined within the 4 corners of the will, that's what's referred to as a testamentary trust. The terms of that trust are within the last will and testament. That's why it's called a testamentary trust. That's not what we're talking about here when we talk about living trusts. What we're talking about with living trusts is a trust that someone sets up, typically in order to, you know how a few moments ago I talked about when somebody dies with assets in their name and they have a will and the assets are frozen, and then the survivors will go through a court process. It may take 4 months, it may take 10 months, it may take 5 years, and they'll hire attorneys and probate expenses will be paid out of the estate of the person who died. And so some people, many people, not some, many people establish what's called a living trust. And the reason they do that is it serves as, one way I could describe it is, I say it serves as a will replacement. The idea with the living trust is, hey, I want to get around my survivors having to go through the probate process when they die. I don't want my survivors to have to wait for months, go hire lawyers, pay lots of expenses. I'd like them to be able to just get it easily as soon as I pass away. So what many people do, they set up their living trust, they transfer their assets to their living trust. So John Doe's house gets transferred from John Doe's name to John Doe as trustee of the John Doe Trust. But now when John dies, not only with a living trust, but also with his assets titled in the name of his living trust. That's what funding your trust is called, transferring assets to your trust. Now, when John dies, things that are titled in the name of John's living trust, when John dies, they're not frozen. No, they don't have to go through a court process. They don't have to hire lawyers. That successor trustee that John named in his trust instrument can go to the financial institution where trust accounts are held. They can bring John's death certificate. They can bring a copy of the trust, and the copy of the trust will show who the successor trustee of that trust is. The financial institution will turn those accounts over to the successor trustee, and then it's the successor trustee's job to distribute the trust accounts to the trust beneficiaries that are listed in the trust instrument. And all that's done outside of the court proceeding. If John's house was in his trust, then the day after John dies, the successor trustee, if they want to, and if it's appropriate, they can plop a for sale sign in the yard of John's house, go ahead and sell that house without waiting on all the delays of probate for anyone to be able to have access to sell that house if selling it is appropriate. Okay, so now you ought to start getting the idea is that this living trust thing, it replaces the will. You create your trust. Sounds like a great idea. You transfer your assets to a trust. Now, when you die, whoever you named as your successor trustee, probably someone that you trust, they'll have the authority immediately to disperse the assets to the trust beneficiaries. Maybe they may disperse those assets to various sub-trusts in the living trusts. So I'll mention again, trust. With wills, some people say when I die, I leave $1 million to Freddie, but in a trust. I don't want to give it to him in one big chunk. I want to leave it in a trust. I want to name Sally as the trustee. Sally will manage all of the assets, invest them, and then Freddie will get it when he's 40, 50, and 60. He'll get it in thirds. So that's when it's in the will, it's called a testamentary trust. Sometimes in people's living trust, John Doe may say, well, when I die, I want $1 million of my trust assets to be set in, to be placed aside in trust for Freddie. Sally will be the trustee. He'll get it when he's 40, 50, and 60. When that's done within a living trust, it's typically called a living trust subtrust. The terms of that subtrust are all part of the living trust. So will sometimes have testamentary trusts. Living trusts sometimes have subtrusts. Hope you're still with me. All right. Now, so we've talked about the difference between the will governs the assets that are in your name. The trust governs the assets that are titled in the name of your trust when you pass away. Okay, so now let's go to number 2 of 3 parts here of if you have a trust, do you also need a will? Okay, so I'll back up a little bit and say the goal for just about everybody who sets this up is to have their living trust. And oh, by the way, they'll still have their traditional and Roth IRAs in their name. That's a non-probate asset. You name beneficiaries. So the will doesn't govern the IRA distribution unless the person names their estate as the beneficiary of their IRA, which is rare and has adverse income tax consequences. But the will typically doesn't govern the distribution of the IRA, nor does the IRA get transferred to anyone's trust while they're alive. The IRA really has to be owned by an individual. Sometimes trusts are named as beneficiaries of IRAs, but my point here is those non-probate assets, the traditional IRAs, the Roth IRAs, the 401ks, the 403bs, the SEP IRAs, the life insurance policies, the annuities, all those things have beneficiaries. And so those, for purposes of our discussion, they're separate. They're governed by beneficiary designation. We're really talking about the other assets, which tend to be houses, real estate, businesses, bank accounts, stock accounts. And so the goal for many, especially if they want to avoid probate, is to create their living trust, designate in their living trust who their successor trustee is, because the person who sets up the trust will be the initial trustee, and that trust will say that that person who set up the trust and is the first trustee can do whatever they want to with the trust assets while they're alive. But the person who set up the trust designates when they pass away or when they're incapacitated who becomes the trustee of the trust to manage everything in accordance with the terms of the trust. So if you've got all that in place and you've got your trust and you've got your assets transferred to your trust, then you'd seem to think you don't even need a will. Well, things don't work out perfectly every time. So the goal here is, yes, you want to avoid probate, you create your living trust, you transfer your assets to your trust, but just in case there's still something in your name when you pass away. Now, that's not the goal. The goal is to have what needs to be in your trust so that all the probate is avoided. But every time someone creates a living trust, they also create a will. And the will that goes with the living trust is, slang term for it is the pour over will, because that will, the effect of the will, it says that, hey, if I own anything in my name when I die, then I direct here in my will that it be transferred to my living trust. Now, if everything's set up right and you have your trust and you have your trust funded, things are titled in the name of the trust, that will never be used. I don't like the fact that I have to say the will never be used. I'm using the word will twice consecutively back to back, but it has two totally different meanings. So if the trust is funded, everything that needs to be titled in the trust is in the trust, and there's nothing in your name when you pass away that gets frozen, that requires lawyers and courts and judges to order the transfer of those assets to the appropriate heirs, then there's no need to use the will, but it's there in case you need it. So it will be needed if, for example, someone creates their living trust and either they neglected to transfer a piece of real estate or a business or an investment account. They neglected to transfer that to their trust while they were alive. Or after they created their trust, they acquired more real estate and they acquired it in their name. They kind of forgot to acquire it in the name of the trust, which is easy to do. Or they opened up a new business, or they opened up a new brokerage account and they titled the new brokerage account in their name instead of titling the new brokerage account in the name of their living trust, John Doe as trustee of the John Doe Living Trust. Now they die, they have some assets in their living trust. The trust controls the disposition of that outside of probate, no problem. But they also have this brokerage account in their name or this business in their name. So now the will is necessary. Got to do all the court pleadings, get a judge to declare the will, the validity of the will, do all the inventory of assets. Just that business or just that brokerage account or whatever asset remained in the name of the person who had created that trust but left an asset in their name, and then you'll use that pour over will or that will and go through the probate, and ultimately at the end of the probate process, judges will sign orders ordering that asset that was in the person's name when they died, that it be transferred to their trust for ultimate disposition just like all the other trust assets, by the successor trustee. All right, so the general answer is, if you have a revocable living trust, do you also need a will? The answer pretty much all the time is yes. Now, you may not use that will because there may be nothing in your name that requires a probate process to be transferred when you die. If you may pass away and all you have is your IRAs, your retirement accounts that are in your name, your life insurance policies where you've designated beneficiaries, those all go to beneficiaries outside of probate. They produce a death certificate, they fill out some paperwork, that gets transferred, no problem. So all of your assets either have beneficiaries because they're the kind of account like an IRA where you're permitted to have beneficiaries, or your assets are titled in the name of your living trust and your successor trustee can disperse those immediately. So there's no use for the will. But even if you have a living will, you have living trust, excuse me, you also have your will just in case you need it, because just in case there's something in the deceased person's name that needs to be transferred to the trust. Okay, so the answer, it's a two-part answer. Do you have a living trust? Do you need a will? First part to the answer is yes, you need a will. Second part to the answer is, if you set everything up, your will is not going to need to be used because there's nothing in your name that requires the probate process to be transferred to survivors. Now, I will say it, when someone creates a living trust, their will, we call it a pour-over will, but really it's a will. And it looks like any other will. It just says, if when I die, I leave any assets that need to go through the probate process, I leave those to my trust. So those assets in your name when you die are poured over into your trust, because the trust is really this controlling instrument that determines who gets everything when you pass away. All right, so there are some things to watch out for when you have that trust and will situation. It is not uncommon for someone to pass away because maybe they didn't just stay on top of their estate planning game and they died. They had certain assets that were titled in the name of their trust, and they also had some assets in their name. So what's going to happen here? Well, the successor trustee of the living trust is going to be able to transfer or disperse or distribute the trust assets really without any problem. But that same person who is the trustee will say, let's say John Doe, I don't like using the common names, but I'm on the spot here. John Doe set up his John Doe Living Trust. In addition, because we said people who have a trust also have a will, John Doe wrote a will, and in his will he says, if I die with anything in my name, I leave it to my trust. And he does. He dies with assets in his trust and assets in his name. So in his living trust and in his will, John Doe, when he was setting all of this stuff up, he said, you know what? Bucky would be the right person to handle my estate when I die, John Doe says. So all of it's written up so that Bucky is the successor trustee of John Doe's living trust, and Bucky is listed as the executor of John Doe's will. John Doe dies with both trust assets and assets in his name. And let's say there's 10 beneficiaries of the John Doe trust. Maybe Bucky's one of the 10, but Bucky is the trustee. Now, the fact that John Doe had his will and his living trust, it's going to make the probate a lot easier. Why would you think having a will and a living trust and John Doe dying with several assets in his name, why would that make the probate easier? Well, it makes the probate easier because Bucky, both the executor of the will and the successor trustee of John's living trust, Bucky is the only participant in the probate proceeding, because at the end of the probate proceeding, things will be transferred from John's estate, of which Bucky is the executor. They'll be transferred at the end of that probate to Bucky as trustee of the John Doe trust. none of those 10 people who are listed as beneficiaries of John Doe's trust will be part of the burdensome and complicated probate proceeding. What makes probates difficult is one of the many things that makes probate difficult is when you have a whole bunch of people involved. They don't understand the court pleadings. They don't understand why this is taking so long. They don't understand why it's expensive. Why don't I have my money yet? John Doe died 6 months ago. I'm supposed to get $200,000. I haven't seen a penny. What's going on? Maybe I should sue somebody. So those kinds of situations make probate a nightmare. But when you have only one participant in a probate, as you do when you have a will and a living trust, and typically it's the same person who's the executor of the will and the successor trustee of the living trust, that probate, while there still are some expenses and there still are some inherent delays, the probate's easier. The easiest probates are the ones with one participant. And so Bucky goes through the probate and gets those assets that were in John Doe's name. He gets those assets and gets the court orders and works with the attorney to get the assets transferred from Bucky's estate into Bucky's trust. Now there's no more lawyer involvement and no more court supervision. Now that the assets have been transferred under the probate proceeding from John Doe's estate to John Doe's living trust, now Bucky can make the distributions appropriately to the 10 beneficiaries of John Doe's living trust, again, outside of court and attorney involvement. So my point is, some people say and are inclined to say, boy, it is a disaster if you create a living trust, but you don't fund it and you leave all these assets in your name. And then when you die, there's a probate required. Why even set up the living trust in the first place? Well, I've got an answer to that, because the probate will be easier because only one person's involved, because the same person is typically the executor of the will and the trustee of the trust. So one person probate and then the trust distribution, which there are 10 participants in that, but it's done outside of court supervision. So just be aware of that, where yes, in a perfect world, if someone creates a living trust with an intent to avoid probate, we want the living trust fully funded so that you don't even have to do the probate and you don't even need to use the will. But if you do have to use the will, it's typically easier to get through a probate if you have one participant than 10 heirs that are listed in a will who all have to share a pot of money under a judge's supervision. Okay, so also they need to be careful. Sometimes people, why they do this, I wouldn't know, but let's say they want to leave $100,000 to their favorite elementary school. And they put that provision in their trust, which is, if they have a living trust, that's where it should be. Want the trustee to distribute $100,000 to the great elementary school after the trust settlor, the person who set up the trust, dies. But then they also put that provision in their will. I leave $100,000 to such and such elementary school. So now perhaps that school gets to double dip. They get $200,000. If there were assets in the estate and there's $100,000 of assets, then the school's going to get those from the will. And then the school also is going to get $100,000 from the trust. So be careful when you start making provisions that may appear both in your will and in your trust. There may be some double dipping there that you'd want to avoid. Okay, and so again, like we mentioned, if you are going to create a living trust, it does make common sense to go ahead and retitle those assets into a trust to avoid the probate, even if it is the one-person probate. And then also, if you are creating your living trust, the question title of this live stream is, if you have a living trust, do you need a will? So, and I think we answered that yes, but it remains to be seen whether that will needs to be used. But then also, if we expand that question further, if I have a living trust, do I need a will? The expansion question might be, if I have a living trust and a will, do I need powers of attorney? So there is something to be said that if John Doe set up his living trust and put all his assets in there, his brokerage account, his real estate, his home, his business, and if he becomes incapacitated, then very likely that trust is set up to say something like, when John either dies or becomes incapable of handling his own affairs, and maybe that might be defined a different way, and then Bucky becomes the trustee of the trust. So if somebody sets up a living trust and they become incapacitated, it's not that power of attorney that becomes the critical instrument. It's the who's listed as the successor trustee in the event of the incapacity of the trust settlor. So then Bucky, if John has a stroke and he can't sign his name, Bucky can handle trust business as in his position as the successor trustee or the incapacity trustee, as opposed to relying on John's power of attorney. Now, John may own IRAs that aren't in the trust, and so you still do need those power of attorney instruments so that if John has a stroke and a distribution needs to be taken out of John's IRA, Bucky can utilize John's durable power of attorney, financial power of attorney, general power of attorney, whatever you want to call it, to be able to go to the financial institution and exercise those rights that Bucky may have to look after John's money using John's power of attorney. So when you have a living trust and you become incapacitated, the people that you designated to handle things, they may handle it either in their capacity of successor trustee of your living trust, or if there are things in your name, they'll handle those things during your incapacity as your power of attorney agent. So just kind of be aware that different positions of authority there. All right. So before we go over to the chat, which I'm looking forward to doing as I do every time we do this, want to kind of sum it up by saying, yes, many people do use a living trust in an attempt to avoid probate. If you have a living trust, you'll also create a pour-over will. You may not use it. In fact, the goal is not to ever have to use your will because the trust is funded properly. But if we have to use it, the one-person probate is easier than the probate where multiple people are involved. So if you have your living trust, go ahead and make sure you fund it and also take care of the incapacity planning, things like power of attorney for financial, medical matters, life support machines decision. That all of that becomes part of that program that we create for our clients when we set up that whole estate planning program to make sure kind of no matter what happens in the future, the right people are going to be handle the right things at the right time, and things are going to go exactly how you'd want them to go with minimal red tape, minimal government bureaucracy, minimal taxes. We want everything, keeping it in the family if that's what the goal is. Okay, so what I want to do next is let's move right over to the chat. See, we've got a good crowd here and we got some good chat going on. So let's go through that. As always, hey, Larry, MVP here, Victoria, nice to see you, Rosemary, Brenda from Missouri, Vicky from Florida, Roseanne from Naples, Florida, KO from California, KO or Q, one of those, Sammy from Atlanta, all right, Tucson, Arizona, fantastic, Maria 28. So put your assets in your trust name if you want to avoid probate. Maybe that's the statement of the day, Maria 28. So you got the top chat so far. Of course, I loved all the hellos, but CAM, and you make me smile every time you do your little emoji. Fantastic. And you seem to be late every time. So I got trust, also a will. So that's exactly the way you have to do it. Hopefully assets are titled in the name of your trust, so we won't have to use that will, but good to see you, Ann. Bill, when you die, does the lawyer get notified to execute the living trust to contact the beneficiaries? So good question, Bill. Another really good question. So does the lawyer get involved? And look, you asked the right person. I've been setting these kinds of things up for people for 33 years, have been involved from the beginning to maybe one spouse dies, to the surviving spouse dies, to the children entitled to inherit, to the children then setting up their own estate plan for their children. Been involved many times through that whole process with families. Here's what typically happens. When you die, does the lawyer get notified to execute the living trust? I'm going to give you the lawyerly answer. It depends. I know that there have been living trusts that my firm has created for people, and I know that person died, and I know that we were never contacted because the family didn't need to contact us. Perhaps the person who died had a home in their trust. Well, the successor trustee put the house up for sale. They sold it. When they went to the closing, the The proceeds were made payable to the trust. The trustee put those in a trust account and then dispersed the funds to the beneficiaries. Maybe the trust had a brokerage account in the trust at Schwab, for example, or it could have been Fidelity or Vanguard or any of them. And the person died, and the successor trustee gets the death certificate of the trust settlor. The successor trustee goes to Schwab, and Schwab permits that successor trustee to gain access to the account. And the successor trustee might sell trust investments, but whether they sell or don't sell the trust investments, the successor trustee will disperse those assets, whether it's investments or cash. That successor trustee will disperse the assets without needing to get the lawyer involved. Now, lawyers do get involved on trust settlements from time to time. So sometimes the successor trustee is just confused because they've never been through this before, and they want some kind of hand-holding as they go through the trust administration process. Sometimes when a settlor or grantor or trust maker or trustor, you call it whatever you want, the John Doe who set up the trust, sometimes that trust does own real estate when the settlor dies, and the trust designates that the real estate is to be transferred to maybe one particular beneficiary. And so when that's the case, paperwork needs to be prepared, typically by the lawyer, so that the successor trustee can sign that paperwork transferring that house or that piece of property out of the trust to the beneficiary. But that could be done as early as the day after the trust settlor died. So sometimes there's some lawyer involvement, unlike every time when somebody dies with a will and assets in their name, there's likely to be court involvement because there's lawyer involvement because there's court pleadings that need to be prepared, and only really lawyers are qualified and experienced to be able to handle all that court proceeding stuff. So, answer to your question, Bill, it depends on the nature of the trust assets and whether the successor trustee and beneficiaries need a lawyer involved to get something done that needs to get done. But I will tell you, just from experience and from not getting those phone calls, or even getting those phone calls with people telling me, hey, my dad passed away 4 months ago and we're done. I was the successor trustee, somebody might tell me, and I got everything transferred to the beneficiaries. We didn't even have to call you. So lawyers don't get involved every time. Nelbo, and I remember the name Nelbo. I had a college friend whose nickname was Nelbo, and maybe that's you. If boyfriend is designated as sole beneficiary in girlfriend's living trust, does that mean he's entitled to all her assets and property and excludes any blood relatives claims? Probably so. So yeah, girlfriend made her living trust. And she said in her living trust, when I die, I want all of the trust assets to go to my boyfriend. Well, that's where they're going to go. Perhaps unless there's some kind of automatic claim that maybe girlfriend had minor child or something like that, where minor children have some automatic right to a certain percentage of the assets. But generally speaking, yeah, if girlfriend creates a living trust and says boyfriend is the sole beneficiary, boyfriend gets the assets. Just like if girlfriend had a will and said, I leave my estate to my boyfriend, boyfriend gets the assets. So and some people think, well, can't the blood relatives just say, I challenge, I want it, and they get it? No, it doesn't work like that. Sometimes these things are challenged either because they didn't meet the validity requirements, or maybe somebody influenced someone into signing something that they didn't really intend to sign. Sometimes people, especially older people with dementia, don't have the capacity to understand what they're doing. So sometimes you see challenges for those kinds of reasons. But no, you got an able-bodied girlfriend creates a trust, names boyfriend as the sole beneficiary. Boyfriend's going to get it. Victoria L. Good question, Elbow. What is time frame you recommend to distribute the trust? If deliver 1/4 at age 35, 135, final 40. Okay. So is this seems fair and normal? All right. I get that question all the time. Paul, what's normal? Or Paul, what do most people do? And I get that you want to know what's normal and what do most people do, but really in estate planning, what's normal or what most people do may not be right for your particular set of circumstances. So I always hate to imply when I say the most common way people do it, I don't want to imply that that's the way that you should do it. These are really personal decisions. And, you put there 25, 30, 35, and 40. That might be the perfect distribution schedule for somebody who's setting this up. And quite frankly, that's kind of common. So if you want to know what's most common, I would say when it's done in stages, most common, not always right, but most common seems to be this 1/3 at 25, 1/2 of what's left at 30, the remainder at 35. But 25, 30, and 35 is not any better than 25, 30, 35, and 40, or 40, 50, and 60, or 55 and 68. So, or 21. I've had a lot of people tell me, yeah, if they're 21, they can have it. And but I would say your Victoria chat about the 25, 30, and 35, and 40, yeah, that seems normal. Again, fair, it's up to you to determine what's fair. And that's all based on a lot of different factors, kind of what you feel is fair, at what life stage is that beneficiary in, at what maturity level has the beneficiary demonstrated. So there's lots of different ways you can leave things. It doesn't have to be based on ages. It can be based on trustee discretion or other factors. So very good question there, Victoria. We're getting some good stuff. Thank you, Dan, for the 4 thumbs up. Not 1 thumbs up, not 2, but 4. So I feel good about that. So thank you, Dan. Positive reinforcement goes a long way. Victoria, do I need to fund all my stuff into trust to show trust is valid? Or as long as I fund one item into the trust is valid? Can I use trust to own, set up LLC? Yeah. So yeah, if there's one asset in a trust, it's a valid trust. But if there's only one of your assets in your trust and other assets still in your name, then when you die, the trustee can only disperse that one trust asset immediately. They're going to have to wait on the probate for the assets in your name to be transferred to your trust for your trustee to be able to disperse those assets. Yes, you can, if you set up an LLC, you can make your trust the member of the LLC. LLCs have members, same thing as owners, but LLCs call them members. So yes, your LLC can own your membership interest. I'm sorry, your living trust can own your membership interest in your LLC. Now your business doesn't have to go through probate when you pass away. That successor trustee can step right in the moment you pass away and continue the management, operation, or transfer of the ownership of the business to the appropriate people. All right, so looks like Osfly Girl, I've seen that name before, jumping in, just inherited 2 trusts, a lot of drama. I was going to say I'd love to hear what the drama is, but maybe I don't want to hear what the drama is. Depends on what that drama is. If it's good and entertaining drama, yeah, I'd kind of like to hear it. If it's not fun drama, then I don't want to hear it. So you just inherited 2 trusts. So maybe that's a good thing. I would think that it is. Okay, try to travel, says Southern California good. My circle of trust is narrowing thoughts of those outside of the family. Okay, great. So I think you're trying to maybe say who should be the trustee of your trust, and you don't know who to trust to make the trustee of your trust. A lot of trust going on there. So we see that a lot. LB, thank you for all your wisdom. You're welcome. Victoria, if my brother is here in USA and my sister resides, if I name my brother first level trustee, kind of name my brother. How can I make my brother has to consult with my sister, but she not has to come here? So I don't know that your sister does have to come here because she's solely a beneficiary. But so there's a lot there. I'm going to skip that one in because that's just Victoria, because there's a lot there. And hi, just to great lawyer. Thanks. Trust your gut on whom you chose and listen to this channel. I don't know anything until this channel. I got my trust now. Way to go. And more happy emoji stuff there. I got my friend on my trust. Okay, very good. So Ann's got somebody there. LV Raider, that's Las Vegas Raider girl. Go Raiders. Didn't make the playoffs, I don't think. My grandfather set up irrevocable trust for me and my father as his sole survivors. We receive money from income generated only. Trustee is a local bank. The trust can't be broken until we both die. So yeah. So that's a little bit of a different scenario, but we talked about sometimes, grandpa sets up a trust and he names the bank, perhaps either during his lifetime or when he dies, names the bank. Banks have trust companies, and some people name individuals to be trustees. Sounds like grandfather named bank, large corporate trust company to be the trustee. That's okay. There's no right or wrong here. And so sounds like grandfather wanted that trust to go on for decades or even generations. So sounds like in that trust, bank is trustee. You are an income beneficiary of that trust. So as that trust produces interest, dividends, perhaps rental property, if the trust has rental property, it produces rental income. You're entitled to all of that income that the trust assets produce, but it sounds like that trust principal is going to sit tight in that trust with the corporate trustee. And at some point, that trust will terminate down the road, and assets will be dispersed to the beneficiaries. But that's what looks, you see that from time to time. Casey Colby, Melbourne, yes, unless her relatives contest the will. Good. That's an answer to a previous question. LB, do you need to file the pour-over will with the court, even though all of the assets are titled? Is that just an option? Yeah, I guess there's a technical answer and there's a practical answer. Haven't researched this for every state, but I know there are states that say if a will exists, then after the person who wrote the will dies, there's a duty to file that will at the courthouse, even though that will is never going to be used because the trust was fully funded. And so that's the technical answer. Now the practical answer is, in many of the probates that I've seen, if the person had a will and the state law says if a will exists, it needs to be filed at the courthouse, but it's not going to serve any purpose because there's no assets in that person's name for that will to govern, then it seems like practically those wills don't get filed, and often there's no penalty for failing to file it because it has no real effect. So good question, LB. I kind of gave you a technical and a practical answer. Brenda Martin, both of my children are in the process of getting a divorce. What do I need to make sure that the exes or pending exes can't get any of my estate? So now we're talking about perhaps leaving, when you pass away, leaving things to your children, not outright, but leave it in a trust for them. And there's a few reasons why leaving it in a trust for them, even if they are their own trustee, can protect it from their past, present, and future divorces. Maybe you look in the description of this video and you click on, and then you can request a Zoom meeting. And if it's appropriate, we can talk about it on a Zoom meeting and kind of go from there. So hope that all works out. Whiskey Business, another familiar name. Our trust and will were written in the northern part of the state. We now live 2 hours away from the town. Can our heirs select an attorney? Yes. Some lawyers sneak their names into the wills that they write and say something like, the will says, when I pass away, I direct that the law firm of sneaky lawyer be the attorney for my executor. So, and again, I haven't researched all of 50 states, but I know of states where that provision that designates the lawyer who wrote the will as the lawyer for the executor is invalid. So that provision is invalid. Doesn't make the will invalid, but it does make that provision invalid. Executors of wills should be able to get help from whoever they want or need to get help from. So should be no problem there, but it could be a state law issue. Whiskey Business, good question. Steve says, what about non-title property? Great question there. Various states have these tangible personal property memorandums. The thing about tangible non-titled property is when you pass away, they're not titled. And again, this is another practical answer. If mom has a will or a trust and she's in all of her estate documents, it generally says, I leave everything to my 3 children, or maybe there's some specific bequest of cash and I leave the rest of my estate to my 3 children. The practical answer is those 3 children typically get together and just kind of divvy up the non-titled property. But let's say mom has some very specific intentions. She says, I want my diamond engagement ring. She says to herself, I want my diamond engagement ring to go to my granddaughter. So mom has a decision to make to either kind of let the family know informally in some non-valid handwriting or communication, and hope that the survivors will honor mom's wishes. Um, or mom can put it in her estate documents, or if her state allows these valid tangible personal property memorandums, mom can document where she wants the non-title personal property to go. So I'd say, yeah, another state specific issue. And there are formal ways to handle non-titled personal property, and there are informal ways to do it. Just depends on what's best for you. So on the back of the wheel, there's a section for that. And great. Okay. And responding to Steve, Shane, hi, Paul, generally speaking, is the cost to establish much different than a revocable trust? I know it's hard to say without details. You're right. It's hard to say. I'm going to just give you the practical answer. There's many different kinds of irrevocable trusts. Sometimes very wealthy people create irrevocable trusts to get large sums of assets out of their estate. Sophisticated tax planning, that kind of planning is more expensive. But and then let's kind of put that aside for now, because that's a different issue. Common folk USA, some common folk, middle class, middle upper class USA will tend to either set up their revocable trust to avoid probate. Some common folk USA, and I'm saying that in a very positive way, will set up an irrevocable trust because, yes, they want to avoid probate, but they also want to get those assets out of the reach of the nursing home expenses if they go into a nursing home years later. And so some of those people will create irrevocable trusts, because putting in assets in a revocable trust does not get them out of your name for nursing home purposes. You still have to spend all of that down. I would say, generally speaking, and yes, it can depend on what kind of assets. Is it real estate? Is it multiple pieces of real estate, or their businesses? How sophisticated do you want to make the distribution schedule of those assets when you pass away? But I'll probably say, just generally, kind of it is similar, although yes, it depends. So that's about as definite as I can be. Boy, we got some good stuff here. Carla says, hi, do we need to hire an attorney lawyer to create the living trust? Most people do. I'd say 95% of people who set up living trusts hire a lawyer to do it, just because there's so much at stake, so many details to deal with. If one thing goes wrong, could really ruin the family for generations. Yes, are there in our technology society, are there online mechanisms for creating it? Yes, there are. In fact, I was even part of one where I helped them with develop the systems to put in place, and our company eventually got acquired, so that company no longer exists. But I would say, practically speaking, 95+% of the people out there who create living trusts get a lawyer to do it, because the right kind of lawyer is going to have the right kind of expertise to make sure you do it right. You want to do it right, because a mistake can be very costly, not only in dollar terms, but in relationship terms for years to come. Alec, what is the average time for a beneficiary to receive funds from the grantor passes away? I'm gathering that even though it will avoid probate, it still could take several months. So yeah, some of the delays that are involved in a trust settlement, oftentimes the successor trustee has to wait on getting a death certificate, and that could take a couple of weeks, or that could take months, depending upon the county, the state, all those things. Because a financial institution is going to want to see proof that the living trust settlor died, and that it's okay for the financial institution to turn that account over to the successor trustee. Really no better way for a financial institution to get that proof that the settlor died than seeing their death certificate. So that's a delay. With financial institutions often want to review the trust instrument and so their lawyers get involved in reviewing the trust instrument. Sometimes there's just delays in the trust beneficiaries maybe needing to create some paperwork or create some accounts that assets can be moved into. So those are typical delays of trust living trust settlements. If you want to go in a different direction, feel free, or be more specific. Victoria says, hire attorney, honest one to do it too, worth it. So again, great time for my little plug. Description below. I own a national estate planning law firm. We do this for people all over the country through our office and our co-counsel network. It starts typically with me, a Zoom call. So feel free to request that in the Zoom meeting. We'll get that out of state co-counsel to participate, and so that you'll have that extra pair of eyes as well. A smaller succession. Don't know, the behavior of people has surprised me. The behavior of what people has surprised me would be maybe my next question. I hope it's not the people in the chat. I don't think it is. We've got great people in the chat. Also taking it in. Thank you. I skipped you, Casey Colby. I'll have to go back and look for you. I scrolled down and I think I missed a bunch of stuff. Technical versus practical answer. Good. How do safety deposit box assets work in a trust? Good question. If someone actually had a safe deposit box and they retitled the ownership to their trust, then their successor trustee, when they die, again, may need a death certificate, should be able to access that box. Or maybe the practical kind of hack. Parents with a safety deposit box in their name will often maybe add a child as having the ability to get in the box. And sometimes the parents die and that child can get in the box that way. So it depends on who the owner of that box is. And there's sometimes probate orders are necessary if that box is in one person's name and nobody can get to it. So there's our own set of safety deposit box rules. Victoria, I have only one son, primary military, 24. Thank you for your service. How do I structure the trust to let the wife have part of my trust if she makes grandchildren for me? If not, she gets none. Well, then you have to make those provisions in your trust. So that if you do have grandchildren when you pass away, then your daughter-in-law will be entitled to perhaps a trust distribution. But if you have no grandchildren, daughter-in-law's out. So you just be blunt in order to accomplish exactly what you're trying to accomplish. Good question, Victoria. Hope you get those grandchildren in the future. I'm in the same boat. Steve says, a section on the back of your will does me no good. My question concerned how not or handled the present pour over will is not involved. Pour over will might be involved. It all depends on how official we need to be with the non-titled personal. And that's a tough one to answer without me being to ask someone questions about what they're trying to accomplish. So irrevocable trust cannot be broken. One depends what you mean by broken. Or sometimes irrevocable trusts are rendered invalid. Sometimes they are if that contest is based on merit, meaning maybe it didn't meet the validity requirements. Maybe the person who set it up was influenced or didn't have the capacity to understand what they're doing. But no one can just say, okay, I'm going to raise my hand here. I'm going to declare that irrevocable trust broken. Doesn't work that way. If something's going to be questioned or contested, then the person has to have merit to do that. So excellent info from California. Thank you. Okay, I don't think I've seen that. Shibui99, thank you so much. Raiders, 100-year-old family farm is part of the irrevocable trust. Okay, very good. Victoria, or let's see, how to structure if the wife and son divorced for whatever reason, she not getting my assets. So again, that divorce protection often involves leaving your estate into a trust for your son so that those inherited assets don't get commingled or mixed up with other assets your son may have with his wife, so that if he gets divorced, he keeps his trust and your son and his wife split other assets that they may have acquired together. Maria, 28, Victoria, why would you give your daughter to care for your future grandson? Okay, I'm going to let Maria, 28, and Victoria have a conversation about that motherly and grandmotherly topic. Okay, let's talk being wise with your lawyer. How do you find a lawyer you can trust? Again, description below. Feel free to check us out, check me out. I love research and want to set up my new relationship with lawyers in an efficient manner. See, I scroll and it scrolls so fast. Let's see. Now would be a good time to both subscribe to the channel and hit the like button. And hey, in the chat, there's a heart button. If you want to throw some hearts out there, that would be great. While I keep trying to keep up with this chat here. Can an individual have 3 trustees, all adult children? It's one of those questions where, can you have 3 trustees, all adult children? There's nothing that says you can't. But sometimes when there's three trustees and they're all, whether they're all children or not, you pass away, you've named your three children as trustees, may have set it up so that they must act unanimously, or you may have set it up that a majority can act. A lot of the financial institutions out there, they don't like to have to deal with more than one trustee. So they won't even allow a trust account where all three have to sign off on it to take certain actions. They'll just say, we're not going to allow it. You got to go somewhere else, or two of the trustees have to resign because we'll only work with one. So just know that there's some issues when you appoint. I'm seeing the hearts go up and up the screen. I love it. Fantastic. Casey Colby, I'm one of 5 beneficiaries of my mom's estate and trust. The trustee, a brother, is about to sell the $1 million summer home for $500,000 to my sister privately. How can I stop it? I think is what you said, but I scrolled and boy, I lost you, but I'm going to go back and find it. Anyway, even if I don't find it, I know what you're asking. Oh, there, I found it. Okay. How can I stop this? Well, your brother, the trustee of your mother's estate and trust, has a duty as the trustee or as the executor to act in the best interests of all of the beneficiaries. So clearly selling $1 million home to a family member for $500,000 doesn't appear on its face to be in the best interests of all of the beneficiaries. So now perhaps what do you do? Court hearings to have the trustee explain why that's an appropriate trustee action. Court hearings to remove the trustee, maybe before they do something like that. So we'll see. Questions from Freeman Diaz. Is it wise to add an adult child onto the deed of the house to avoid probate and taxes? So with real estate, yes, we get that question a lot. Should you add somebody to the deed? So let me give you the backstory on that. A lot of people say, well, should we add our child to our bank account so that they have signature authority so they can get to our money when we pass away? But there's a difference between that and real estate. So when you adding someone to a deed, does that mean you're making them an owner? And are they just a partial owner? So they own maybe 25% and you own 75%. And then when you die, the probate is necessary to transfer your 75% to the appropriate heirs or beneficiaries. So that adding to the deed is a lot of caution there. I would say, no, that's typically not how people address make it easy for people to acquire my real estate. Do you want to make them the sole owner now? And there's some reasons why you wouldn't want to do that. No step up in basis. Maybe you don't want to leave it all to that one person. So typical way, put your property in your living trust, pass away, step up in basis, no probate. Trustee can sell it or transfer it to the appropriate beneficiaries. Jackie, how far out are you scheduling? Can you read over and advise me on how to work within it? Probably not going to help. That's why you fill out the questionnaire. If in your questionnaire, you're like, I just want you to read over a trust and guide me. That's really not our bread and butter. Our bread and butter is taking people who, hey, we want to create a plan from really start to finish. And we have these goals and we want to have you, Paul, help us reach those goals. But give it a shot. And if you pass through the questionnaire status and you get my calendar through technology, you'll see how far I work out. Okay. He has breached, Casey has breached his fiduciary duty in multiple ways. Can I sue him for the breach and legal expenses? It's a scheme to avoid a fair market value buyout that keep the property at deep debt. Well, thank you, Casey Colby. King Otis Club. Does the irrevocable living trust need to be notarized in order for a pour over will to work for real estate property going through probate? Probably. Depends on, that's a state specific. There's a few states out there that you can create a trust and it doesn't need to be notarized, but state specific issue. I generally like to see all the trusts. And is that what you're asking? Does their trust need to be notarized in order for a pour over will to work for real estate? That's a very, very specific state specific question. So I'm just going to leave it at that. You're welcome, Freeman. LB, would you need have a lawyer file if changing trustees or a trust or removing trustees? Changing trustees of a trust. Well, maybe if one trust resigns and then the position falls to the successor or next in line trustee. I don't know that you need a lawyer for that. If you have a trust and your trust says Bucky's going to be your trustee when you die and you want to change that, yeah, you'll likely need a lawyer to do a trust amendment or a trust restatement because you've changed your mind about what you want the trust terms to be. All right. Thanks, Raider Girl. Go Raiders next season. Victoria, maybe you'll have a good draft, by the way. Okay. Victoria's addressing Key Notice Club. Anne says, I got to go. Great. Double emoji and hearts. And you got it going on, making me feel good, Paul. Carla, Paul, if you have two properties, want to give each child one property, is it possible? Two trustees, how do I schedule a Zoom meeting with you? I'll start with the end. You schedule a Zoom meeting or at least request one by looking in the description of this video. You'll see a link that you can click on and fill out a form requesting a Zoom meeting. If the meeting's appropriate, we'll send you an email back with my calendar and you can schedule it right there. If you have two properties and you want to give each child a property, is it possible? Yes. So if you're going to use a living trust to do that, you'll create your living trust. You'll transfer those two properties to your trust. And in the trust instrument, it may say something like, when I pass away, I leave this piece of property, 123 Sesame Street, to this child. And I leave this piece of property, 789 Sesame Street, to this child. It's as easy as that. When you pass away, that successor trustee or co-trustees can sign the paperwork transferring that property out of your trust to the appropriate child. And there you go. All right. Good question, Paul. If we, let's see here. Paul, if we sign up service with your firm, do I get you to work on my trust, or will you assign some other junior attorney? I like the way you do that. Paul, will I be able to work with the big gun? Or are you just going to throw me to one of the junior attorney wolves? I like the way you said that. Just reading between the lines. So for right now, all of the kind of new client matters come to me, and I'm responsible for making sure we'll develop that plan together. Do I have other people who help me dot the I's and cross the T's and are better at certain aspects of trust funding and different things? Of course I do. But it's my responsibility to make sure everything gets done right, and it starts with me. All right, so maybe I'll say see you on the Zoom call, Victoria. All right, Raider Girl, my father and I were able to change the AM, whatever that means. King of the Trust wasn't funded at all, Paul. Casey, you read my question but didn't answer. And so, yeah, I'm going through these so fast. And sometimes I read a question and in my mind, I'm like, boy, I wish I could just have a back and forth dialogue with the person who asked the question. So, all right. But thank you for your patience there. Raider Girl, bank trustee to a different bank by agreeing both. Okay. Thank you, Paul. Stay warm, buddy. Larry, always great to have you. Larry's the MVP from California. Always great seeing Larry before, during, and after these presentations. Carly, you're welcome. All right. We're wrapping up here. Any mortgage company, foreclosure. Okay, I'm going to skip that one because I'm in a hurry and I need more information. So yeah, Jackie says, how much does it cost? On our website, we've got some kind of ranges there. So you can look at that. I would say, well, let me just refer you to the website, which is in the description below. All right. Thanks, everybody. This was, we really rocked it tonight. We'll rock it again tomorrow night. It'll be up on the website. I'll put some chapters at the bottom here momentarily. So if you look at if you're watching the copy of this, it'll be well organized and well chaptered. Thank all of you so much. Thank Larry. Thank Victoria and Raider Girl. All you guys who are showing up regularly. Love it. And so my only goal here is to get as much of information as we can to as many people so you can make informed decisions. Take care of yourself, take care of your family. I don't know that anybody else is going to take care of you. So let's all do this together. We'll see you next time. Have a great one.